because discovery is incomplete.
All right. Is there somebody here with you, or did they send you on your own? No. They sent you on your own?
Yep. Amanda took the day off.
Okay, there's supposed to be a green form filled out.
I'll fill it out.
Could somebody help Mr. Benson? Thank you. All right. Probable cause conference in this matter will be adjourned to July 17th, 2025, at 9 a.m. Bond on this case will continue. Mr. Gonzalez.
Okay, pause right here. This is the calm before the legal storm. What you're hearing is the judge addressing bond continuation, but notice that ominous phrase. Violation of probation warrant. That's code for serious trouble ahead. When a no bond warrant drops, it means someone's past is catching up fast. Should prior violations always lead to automatic remand? What do you think? Comment yes or depends below.
I was informed, and I think you have been informed, that there's a violation of probation warrant. And that has no bond. So, on it. Mr. Benson, did you want to, you don't represent him on that?
No, I don't, but I've talked. And Your Honor, on this present case, could he have at least $100 cash bond so he earns some time?
People don't have an objection to the cash bond, Your Honor.
I'll set his bond in this, on the case that I just called, as a 1,010% bond. All right. But on the warrant was issued by Judge Slay. There is no bond. It's violation of probation warrant. I'm going to remand you to the Washtenaw County Jail.
Try to get you arraigned
The time that you can be heard in that court. All right, he's remanded.
And good morning, Your Honor. Sydney Rushing appearing on behalf of Mr. Jones on case ending 0697.
Mike Gaddy, Assistant Public Defender, on behalf of Mr. Jones in case 21.
Here we go, textbook plea colloquy. The judge is making sure this isn't a coerced confession. Watch how thorough she is. Every right, every consequence, every fine print. Why? Because once that guilty plea hits, there's no rewind button. Ever wonder why the system insists on waiving trial rights in such detail? It's about protecting the record. The court wants no surprises on appeal.
574.
Okay, in both cases, I have an indication that there are plea agreement form that he is going to be pleading guilty to an added count 2 of use of a controlled substance in both matters, a 1-year offense. On a successful plea, with those charges count 1 in each case. Yes.
That is correct, Your Honor.
That is correct, Your Honor.
All right.
I have gone over his rights with him.
May I have him sworn?
Raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Help me God, yes.
State your name.
Quincy Jones.
All right. Sir, it is this court's understanding that you're going to be pleading to 2 counts of use of a controlled substance.
Yes.
All right. Is that correct?
Yes, Your Honor.
Those are misdemeanors, punishable by up to 1 year incarceration and $2,000 fine plus court costs. You understand that?
I understand, Your Honor.
You understand also in one of the cases, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Barr in the 14H2 District Court.
Yes, Your Honor.
Understanding all of that, do you still wish to plead guilty?
Yes, Your Honor.
To the charge of use of a controlled substance contained in case ending in 0697, how do you plead?
Guilty.
To that same charge contained in case ending in 0574, how do you plead?
Guilty.
Now you understand that by pleading guilty, you'll not have a trial of any kind.
Yes, I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes.
You have any question regarding any of those rights?
No, I read them thoroughly.
Pardon?
I read them thoroughly.
You understand them?
Yes, I do.
All right. So you have no questions?
No questions at all.
Is anybody? I think we look at paragraph 5, excuse me. Copy on the podium. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that.
Yes.
You understand you're giving up your right to appeal of right?
Yes.
Are you on probation or parole?
No, I am not.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
He's asking if anyone's made you any promises.
No.
Anybody threaten you or coerce you in any way?
No, they haven't.
You're doing this voluntarily?
Yes, I am.
Of your own free will?
Did you catch that? Cocaine and fentanyl. 2 separate cases, 2 admissions, and 1 big red flag for sentencing. The fact that the second incident happened inside jail raises the stakes dramatically. This isn't just about drug use, it's about addiction, custody security, and judicial trust. Should sentences be harsher for offenses committed while already in custody? Let us know what you think.
And because you believe that you are indeed guilty of these offenses? Okay. Starting with the case in the 14A2 jurisdiction, City of Ypsilanti, on March 14, 2025, the location of Huron Street, City of Ypsilanti, Washtenaw County, State of Michigan. Did you have cocaine in your possession?
Yes, I did.
Had you used it?
Yes, I had.
Did you know what you were using was cocaine?
Yes, I did.
And on the other matter, on the date of February 9th, 2021, at the location of 2201 Hogback Road, that being the Washtenaw County Jail, did you have cocaine? Did you have fentanyl in your possession?
Yes.
Had you used it?
Yes.
Did you know what you were using was fentanyl?
Yes, I did.
All right. Sir, I need you to also understand that if I accept your plea and between the time of sentencing and the time of, between this plea and the time of sentencing, if you commit misconduct as defined by the court rule, that any agreement or sentence evaluation or case evaluation the court is not bound by that. You understand that?
Yes, sir.
You also understand that you could not then set aside your plea.
Okay.
You understand that, sir? All right. Is counsel aware of any other promises, threats, or inducements that have led to these pleas?
No, Your Honor.
No, Judge.
And has the court complied with the court rule, and would it be proper to accept the defendant's plea?
People satisfied on both matters.
Yes, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's pleas of guilty to count 2 in each of the cases. Count 1 is dismissed. In the 14A2 matter, pre-sentence investigation and report is ordered at 14A2 probation. Sentencing in that case will be July 9, 2025, 10 a.m. That is before Judge Barr. Bond on that matter will continue.
Your Honor, may I address Bob?
I knew it. I was trying to sneak it in before you said something, Rushy. In the other matter, let me just finish up the other matter. In the other case, defendant is count, if I didn't say so, count 1 is dismissed, except the plea to count 2, count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A1 probation. Sentencing will be no.
That was the prosecution's mic drop moment. They're stacking the timeline. Drug use, hospital visits, failure to test, all before this hearing. And now they want him held until sentencing. It's not just about punishment anymore. It's about public safety and compliance history. Is the judge leaning toward caution or compassion? Keep watching.
Have a sentencing time. He's in custody. That's the date we'll give. July 9th, 2025. Time?
9 a.m.
9 a.m. So you can come here and then get over to Judge Barr, and that's before me. As to bond.
Your Honor, I'm asking that Your Honor consider reducing this down to a personal bond. Bond was revoked because Mr. Jones failed to come to community corrections. I know Your Honor is very well aware of the last time. Exactly. But Your Honor, but Your Honor,
it wasn't just he didn't go to community corrections. Isn't that correct?
That was, Your Honor, something may have happened prior to my appointment, but when I was appointed on the matter, he hadn't came to community corrections.
Yeah, he probably came down off all those drugs. Go ahead.
Well, Your Honor, that's new information to me. But at this time, he has accepted responsibilities in this matter. He will appear at his sentencing date. I've had a conversation with him. He understands that he does need to turn himself into community corrections and he does need to test. So I'm asking Your Honor, consider reducing this down to a personal bond.
Your Honor, I would just add that I have been in touch with the social worker assisting him from Avalon Housing, and they are prepared to help him engage to whatever extent is necessary.
Any response from the people?
Yes, Your Honor, and happy to fill in Ms. Rushing as well. Prior to her appointment on that other matter, Mr. Jones had appeared in court extremely under the influence amounts of multiple drugs that he admitted to. I think it was cocaine and THC at the time. Not sure what else may have been in his system. The concern for the people added to that is that prior to that, Eric's court under the influence, Mr. Jones had actually been in treatment and been hospitalized. So I'm very concerned that he's just not able to comply with the court's orders of saying he using drugs. And it was then that his failure to report for testing after that occurred after he had still been allowed to be released on PR. I would prefer that he at least remain in custody until his sentencing on July 9th.
All right, until I have an additional evaluation, I'm going to deny the request for any type of bond reduction. Defendant bond will continue in each case.
Thank you, Your Honor.
Thank you.
Happy holiday, Judge.
Yes, and to you.
Have a great day.
Court calls the case, People versus Elton Bell. Your name, sir?
Daniel Franklin.
Thank you. All right, what are we doing on this case?
I spoke with Mr. Johnson. I don't know what has been, I believe he has been tendered discovery, and I think we're just looking to set this matter for an examination.
Is that a correct statement, Mr. Johnson? You'd like this matter set for prelim?
Yes, Your Honor, and we're asking that the prelim be set out a ways. I believe the people will be calling a cooperating witness who is in federal custody because of the likelihood that this witness may become unavailable down the road. I will be asking for the people to present any and all information they have relevant to cross-examination under US v. Giglio. And I think the people may need some time to get that. And I don't know if the people are even in possession of the federal indictment in which this witness is cooperating under and giving this testimony. But I would like to have that before exam as well.
I have no problem with that. I have no problem with setting this matter out. As the court may remember, Mr. Franklin is being held on another homicide case that is pending before Judge Conlon with a trial date well into the fall. The reason...
So why am I setting it for exam if everything's not ready?
This cooperating witness is currently being held at FCI Milan. The moment we have an examination date, I can give a writ to them. They won't transport him. Otherwise, it sounds like he's going to eventually go to West Virginia, and I'd like to have that writ before the Bureau of Prisons transports him out of the state. So the date...
Especially to West Virginia, because people don't come back. No, I'm kidding. I love West Virginia.
I don't know. Okay. And so that would be the reason I know, and as I spoke, Mr. Johnson and I spoke yesterday, and I believe we're on the same page.
All right. So to get accomplished everything, how much time are you guys looking at? I get why you want a date out. I'll set the exam, but...
Perhaps, I don't know what the court's availability is. I'm looking into kind of
mid-August. I can do August 12. I can give you a prelim date on August 12th.
Your Honor, on August 12th, I have another homicide exam in the Lansing District Court.
Gotcha. Well, that's my only set PE date in that date. Did you want me to kind of give you a Monday and that way more flexibility to do that?
August 11th, if the court is available that day, that would be perfect for me, Your Honor.
Monday would be fine, and just for the court scheduling purposes, I wouldn't expect this to be something that would take more than half a day. So
okay.
That'll be a full day examination.
That's okay. So what I'll do is I'll just put it on my docket. I should have asked, do I have the 11th available? And if we don't pick a jury selection in the morning, so I can set it in the afternoon. Oh, I did set an order here. Okay. All right. I can do Monday the 18th. Will that work for you, Mr. Johnson?
I'll be at a jury trial in the Washtenaw County Circuit Court on the 18th, Your Honor.
No way. No, I'm kidding.
The 25th works for me if that works for the court.
No, because I'm gone. Well, I know it's going the other direction, but would August 4th work?
I think August, at least from the people's perspective of getting the information to Mr. Johnson, August 4th would work for us.
Mr. Johnson, August 4th work?
I will be in trial August 4th, Your Honor.
The whole day?
Yes, Your Honor.
All right, give him a Tuesday. I don't know what Johnson's schedule is. I don't know why I'm setting around Johnson anyway.
My other thought is if we could set it on a Tuesday, perhaps that 12th, knowing that we would then get closer to the date and perhaps talk with the court about a skip to move it. As long as I have the date to hold this witness, I don't care if we move it. I can send.
Why don't I do this then? And then this way you can kind of figure it out, and then we can move it to give you more flexibility in terms of dates, because then we'll be able to figure out my dates a little bit. I'm going to set it on July 22nd. Okay. With the understanding that you guys may have to move it, but then we'll move it on my docket.
That's fine.
Okay.
Yes, Your Honor.
So preliminary examination in person will be set July 22nd, 2025. That's at 12 noon.
Yes.
So that's an afternoon prelim docket or PE docket for me. All right.
Thank you,
Thank you, Your Honor.
All right.
Mr. Johnson, I'll contact you early next week and we can go over
Yes, sir.
everything, okay?
All right. Thank you, Mr. Johnson. Court calls case People versus Lakita Roberts. Lakita.
Mike Gaddy, Assistant Public Defender on behalf of Ms. Roberts, who's here to my right. Your Honor, state your name, Ms. Roberts.
Lakita Roberts. Thank you.
Welcome.
Your Honor, I'd ask to set this matter for an examination.
For exam.
Yes,
All discoveries complete.
I have reviewed the file. Looks like it is, Judge.
I believe so. I did want to just confirm with Mr. Gaddy.
I'm happy to talk about a global resolution. I've spoke with Mr. Ward about that as I was instructed to do, and he and I are going to continue talking, Judge.
People have their witnesses available this 15th.
If I can be
Your
heard.
examination in person, July 15th, 2025, 9 a.m. That is before Judge Washington.
If I can be heard, I'm fine, Judge.
Sure.
Thank you. Your Honor, Roberts has been in custody for several weeks. Excuse me, I had a frog in my throat. She does have a place to live. She lives locally. She would, I think, I'd ask the court to give her an opportunity to avail herself of using a scram tether to ensure that her appearance in court, as well as any testing or other monitoring provisions that the court would deem necessary to ensure her appearance. She does. I'd ask the court to, her bond is set at $25,000 in this matter. I'd ask the court to, she does have a couple other matters that are pending. She has the matter in circuit court that Mr. Ward and I have also discussed. I believe her bond is $50 in that matter. Her bond's $100. Her bond is $100, I think, in a 14B court, 14B district court case where I think it charges illegal entry. So I'd ask the court to consider reducing this bond to something that she may be able to post with or personal cognizance with any conditions that the court deems necessary to ensure her appearance.
Response.
Your Honor, I would object to any change of bond conditions right now. Ms. Roberts also had a domestic violence case pending. I understand it was a final settlement and may have been dismissed yesterday.
It was.
That was a newer case, however. Ms. Roberts, this case is a bit older. It looks like looking at the previous notes, there was a bench warrant issue for $25,000 cash or surety for failure to report to court, as well as community corrections. I think a subsequent violation for community corrections as well. I'm concerned, obviously, about the substance use in this case. I don't think that, given her history of failure to appear and some new offenses in the interim and failures to appear on this case and other cases in circuit court, that we can trust Ms. Roberts to, on her own, comply with court orders and show up.
Your Honor, the DV case was dismissed yesterday in my note.
Does she have any other things pending at this point or no?
No, just this matter, the illegal entry case in 14B, and there's a circuit court case with a $50 bond, Judge. There is a whole
$50 bond in her circuit court?
yes.
That was just because she had a bond in something else.
Yes, that's my understanding. It's a very old case. It was bench warrant. I think for some reason I don't think the bench warrant ever got on lien because the jail didn't know about it until it was brought to their attention during the pendency of this
case.
case.
Granted. Defendant's bond is set at $5,000 personal recognizance bond. Defendant is to report over, and we'll do a new community corrections test. She's to report over for once a week testing.
Okay, thank you, Judge, and we'll work on the other bonds as well. Thank you.
Thank you, Your Honor. Thank you.
And Alex Warren Green on behalf of Stringa. Can you state your name?
Leo Stringa. Thank you. Okay. I have before me two plea forms. It's going to be pleading to 2 counts of in two different cases to retail fraud, second degree, the 1 year offense. On a successful plea to that charge, count one would be dismissed. There's also an indication that a case out of 1482, which is a retail fraud third degree, would be dismissed on a successful plea in these cases.
That's all right, John.
And that's our full understanding, Your Honor. Mr. Stringa is asking the court to consider a no contest plea to both of those counts.
And here's where it gets weirdly compelling. Lack of recollection as the basis for a no contest plea. Yep, he's basically saying, I don't remember, but I won't fight it. Legally valid, emotionally loaded. Why might someone plead this way? Often to avoid incriminating themselves further, especially if there's civil liability. Smart move. Risky dodge. Sound off below.
Do I have reports? It does say no contest plea. Yes, I do. I saw these reports. Okay. All right. May I have him some more?
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give you the truth, the whole truth, and nothing but the true self you got?
I do. Leo Stringer.
Sir, it is this court's understanding that you are going to be pleading to 2 charges of retail fraud in the second degree. Is that your understanding?
Yes, it is.
All right. Those are misdemeanors, punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. The fine could be increased to 3 times the value of the property taken. If that's greater than $2,000, that would become the maximum fine. You understand that, sir?
Yes.
All right. You understand what a no contest plea is?
Yes, my attorneys described it.
All right. 2 things about a no contest plea. I have to make sure that you understand it. First of all, it means that as to each of these cases, you have no desire or do not wish to contest these charges. You understand that?
Yes, I do.
Second thing you need to understand is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
And you understand also, sir, in one of your cases, the case ending in 5508, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court.
Okay.
You understand that?
Yes.
Basis for the no contest, please.
Lack of recollection, Your Honor.
All right. Sir, to the charge, I'll start with the 15th District Court matter. To the charge of retail fraud, second degree, I'll just give you an offense date. Having occurred on November 20th, 2024 in the city of Ann Arbor, how do you plead?
No contest, Your Honor.
To that same charge, having occurred on November 20th, 2024 at 3825 Carpenter Road, that being the Meyer in Pittsfield Township, how do you plead?
No contest as well.
Now, you understand that by pleading no contest, you will not have a trial of any kind.
Yes.
You signed an advice of rights form?
Yes, I have.
Any question regarding any of those rights?
No questions.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights, which are part of the trial. You understand by pleading no contest, you're giving up those rights as well as all the rights in that form.
I do, Your Honor.
You understand you're giving up your right to appeal of right.
Yes.
Are you on probation or parole?
No, actually. No, the probation that I was on I'm done with.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
No.
Boom. Sentencing locked in for July 29th at 9 a.m. But notice how efficiently this plea deal wrapped up 2 cases, dismissed the most serious charges, and even protected the defendant's future by avoiding a full-blown trial. It's courtroom chess. Quiet, strategic, and always high stakes. If you've ever wondered how plea bargaining keeps the justice system from collapsing under its own weight, this is it in action.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily
Yes, on my own accord.
and of your own free will.
That is as well.
The court has been provided and has reviewed University of Michigan Department of Public Safety and Security for their case number 24-903-06211, as well as Pittsfield Township Department of Public Safety report for their case number 24-19305. Any objection to the court having reviewed those reports?
None from the defense, Your Honor.
Okay. based upon a review of those reports, the court would find that there's a sufficient factual basis to determine the defendant's guilt. Sir, you understand that if I accept your plea, in this case, between the time of the acceptance of your plea and the time of sentencing, if there's misconduct committed by you as defined by the Michigan court rules, you would, one, not be entitled to withdraw your plea, and two, any resolution or evaluation regarding this case, the courts would not be bound by in terms of sentencing. You understand that, sir?
Yes.
All right. Is counsel aware of any other promises, threats, or other inducements that have caused this plea?
None from the defense, Your Honor.
Has the court complied with the court rule in both of these matters?
And the defense is satisfied.
Court will accept the defendant's plea of no contest to count 2 in both cases. Count 1 is dismissed. In the 15th District Court matter, a pre-sentence investigation and report is ordered at 15th District Court probation. Sentencing in the 15th District Court matter will occur on July 29th, 2025 at what time? 9 a.m. before Judge Balvo. In the other matter, court does accept the defendant's no contest plea to count 2, count 1 being dismissed. The pre-sentence investigation and report is ordered at 14A1 probation. Sentencing in that matter will be July 9th, 2025, 9 a.m. before me. Bond in each of these matters will continue. Thank you.
Thanks, Leo.
Thank you, Your Honor.
Thank you, Your Honor. That's my favorite person.
Proposed case, People versus John Terry.
Your Honor, Alexis Pluma appearing with and on behalf of Mr. Terry. Mr. Terry, could you state your full name when you get up here?
John Martin Terry.
Thank you.
And Your Honor, I believe the court has received a plea form as well as a signed advice of rights form. Mr. Terry will be pleading to an added count 3 of controlled substance use, and counts 1 and 2 will be dismissed.
That is what the court has in front of us. Is that a correct statement? All right, let's have him sworn.
Raise your right hand. Do you solemnly swear to affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
State your name.
John Martin Terry.
All right. He needs to acknowledge box 5 needs to be checked on that form. Okay, sir, it is this court's understanding that you're going to plead guilty to the charge of use of a controlled substance.
Yes, sir.
That's a misdemeanor punishable by up to 1 year incarceration and $1,000 fine plus court costs. You understand that?
Yes, sir.
All right. You understand also, sir, that while I'm taking a plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in the 14A2 District Court.
Yes, sir.
All right. Understanding all of that, you still wish to plead guilty?
I would, Your Honor.
And to that charge, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
I do, Your Honor.
You signed an advice of rights form, is that correct?
Yes, sir.
Any question regarding those rights?
None, Your Honor.
Please look at paragraph 5. Those are your rights which are part of a trial. You understand by pleading guilty, you'll be giving up those rights as well as all the rights on that form.
Yes, sir.
You understand you're giving up your right to appeal of right?
Yes, sir.
Are you on probation or parole?
No, sir.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead?
None whatsoever, yes, sir.
Anybody threaten you or coerce you?
Not at all.
You're doing this voluntarily?
Yes, sir.
Of your own free will?
Yes, sir.
And because you believe that you are indeed guilty of this offense?
I am guilty, sir.
On the date of August 9th, 2022, at the location of Prospect Road near Berkshire Drive in Superior Township, Washtenaw County, State of Michigan, did you have heroin in your possession?
I did, sir.
Had you used it?
Yes, sir.
And did you know what you were using was indeed heroin?
Yes, sir.
Sir, I do have to advise you that if I accept your plea, if there is misconduct committed by you as defined by the Michigan court rules between the date of this plea and the time of your sentencing, any plea agreements and or evaluations the court would no longer be bound by. You would also not be eligible to set aside your plea. You understand that, sir?
Fully understand that, sir.
All right. Counsel, are there any other pleas, threats, or inducements that have caused this plea that have not been stated on the records?
No, Your Honor.
Have I complied with the court rule, and would it be proper to accept this defendant's plea?
Yes, Your Honor.
Yes, Your Honor.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be
July 15, 2025, at 10 a.m.
July 15, 2025, time 10 a.m. before Judge Barr.
Thank you, Your Honor. And may I address bond?
What would the case be if you didn't? Go ahead.
Your Honor, so we did discuss this last week. I would just ask you to consider again a personal recognizance bond for Mr. Terry now that he has pled to a single misdemeanor. He does now have reliable transportation to court in the form of his mother and his own transportation. He has a job at Tradesman that he could go back to. Again, he did admit that he had a slip up with regards to his sobriety, but he is committed to doing better. He's provided proof that he was enrolled in medically assisted treatment as well as mental health services through Packard Health and CMH prior to going into custody. And he had already completed an access interview with Home of New Visions and had planned to enroll in intensive outpatient treatment again, prior to the bond violation, and would plan to do that if released, if Your Honor, again, would consider a personal recognizance bond.
So there's no plan set up for what he's going to do at this point?
There is.
It's my understanding that he was approved to participate in intensive outpatient through Home of New Visions. He would just need to contact them after he is released.
Yes, sir.
Anything from the people?
Your Honor, Mr. Terry has been able to provide through his counsel a proof of the treatment that he's been undergoing since February or March of this year. So we would leave it up to the court's discretion since he is.
Well, I'll tell you what, I'm going to deny at this point, but the reason my understanding is you would be shortly seen by 1482's probation. And certainly that can be then addressed by Judge Barr as to his release. All right, consistent with what they see. So at this time, I'll deny your motion for bond modification. Bond will continue.
Thank you, Your Honor.
All right. Thank you, sir. Good luck to you.
Yes, sir. Thank you.